Hi, so I'm going to talk about Information Technology Amendment Act and its implications for intellectual freedom in India. So first of all, what is intellectual freedom? So, Universal Declaration of Human Rights, Article 19, everyone has the right to freedom of opinion and expression, and this right includes freedom to hold opinions without interference and to seek blah, blah, blah. I mean, you can read it. But the key question is, intellectual freedom is an abstract idea, right? It's kind of like privacy. How do we define it? But, the definition of the concept might be difficult, but we definitely know that there are certain things that help facilitate intellectual freedom. Should I leave this now? Okay. So some of those things are, right to privacy, right to freedom of expression, and, there's more things. So the things that I'm going to be concentrating on is privacy and freedom of expression and how that is impinged upon by the Information Technology Amendment Act of 2008. So for starters, so this is going to be kind of the outline of my talk. I'm going to talk about the historical background of the act, its implications for privacy, its implications for freedom of expression, other criticisms. So obviously, it's not going to be, it's not going to have a positive. It doesn't have a positive impact on privacy and freedom of expression if it's followed by other criticisms. And then I'm going to conclude. So this act was originally passed in 2000, and essentially the idea was that India did not have a law that dealt with the emerging field of cyber technology and information technology architecture, and at the same time, this was at the height of the the BPO revolution and the IT boom in the late 90s, and basically a lot of companies, American and European, were investing in the Indian market because they had discovered that wonderful thing called business process outsourcing, and they realized that they could get a lot of cheap labor in India because of GDP per capita or PPP. So the Indian government was like, oh, great, you guys are bringing us money, sure, we'll make a law for you, right? And so they were really only interested in facilitating electronic commerce, and that's what they concentrated on. The problem was that people who make laws in India, they're not very smart. They're not even very, no, actually that's wrong. People who make laws anywhere are not very smart, but they're also not very literate, So essentially, if you're trying to make a law for information technology, you need to have a basic grasp of what information technology is, right? You need to at least know, if you're making laws in 2000, you need to at least know what is Windows 95, what does a keyboard look like. This is not essentially, this is not necessarily true for many of the Indian politicians who failed to pass the 5th grade, right? So that's a huge problem. And so they had some key problems in the areas of cryptography, digital signatures, and cybercrime, which basically ended up in a huge scandal in 2004 where this British company, this British investigative agency did this documentary where they showed how Indian BPO workers were selling financial and personal information of Americans and Britishers on the black market. Well, it's not even black because it's not really illegal because it's technically legal to do it in India. It's a gray area. It's not very well monitored. So there was a lot of pressure to come up with better regulations for data privacy. Just so you know, there's no privacy law in India per se. I mean, it's kind of guaranteed through certain articles, but there's no explicit mention of personal privacy. So in 2006, they came up with another amendment, that was mostly about data protection. Now in 2008, this thing happened. Are you guys familiar with the attacks in Bombay, where there were some terrorists who came to Bombay and they managed to hold hostage the Indian government for 3 days? Six guys, 12 guys, which tells you something about the competence of the anti-terrorist act, anti-terrorist measures that the Indian government takes, right? If 12 people who are not even very well trained can hold you hostage for 3 days. So there was the whole thing that, if we had been able to tap their conversation, if we had been able to, monitor their, the wireless and all the other communication media that they were using to plan this attack, that we would have been aware of the attack and we might have been able to do something about it. So to that end, in 2008, they came up with a bunch of other amendments, which are basically relating, talking about, arrest and wiretapping and all those wonderful things that we love and cherish, right, as part of a free society. So that brings us to the act itself. So what parts of the act guarantee privacy? So there's Section 43A and Section 72A. And then there's something called the Information Technology Rules, which I guess are also being followed up with something called the Privacy Bill, although I'm not really familiar with it. But basically what Section 43A does says is, where a body corporate processing, dealing, or handling any sensitive personal data of information. And so it goes on. But basically what it's talking about is reasonable expectation of security measures, right? If you are collecting some sensitive information, you are expected to provide some kind of security and measures that would take care of privacy. And so what 43A provides, it provides a channel for civil lawsuits, that if you feel like that your service provider is not taking what would be considered reasonable precautions, and at the same time they're collecting a lot of information and making money off of it, then they can be sued for civil damages, right? Now 72A is slightly different. This is not about reasonable measures. 72A talks about someone who's collecting information with a malicious intent, right? And so this is talking about criminal liability and not just civil liability. So these are the two main sections that deal with privacy. The problem is both these sections only talk about private entities. There is no mention of the information that is collected by the government. I think everyone will agree that the government collects a ton of information. I mean, that's not the United States, it's every democratic government in the world, right? Which brings us to section number 69. Section number 69 is a wonderful section that allows law enforcement agents to do warrantless wiretapping. Now, anyone in this room who's not concerned about that? Anyone in this room believes that law enforcement agents are so nice and so, they're always just, looking out for you, that they can do, wiretaps at any point of time? This is a huge problem, not just because they're allowed to do wiretaps, but also because the level of people who are allowed to do wiretaps. Because originally, when the article was written, it had to be someone of the rank of commissioner, which is a reasonably higher up rank in the local law enforcement and the police. But now, even an inspector is allowed to issue, basically call for a wiretap. And there's not a lot of documentation that they have to maintain for something like this. And not only that, if you have someone who's of the rank of the inspector, so if you just think of cops in your own town being allowed to wiretap you, right, and keep that information for an indefinite amount of time and use it for any purpose, I think it's slightly scary. Not only because the cops might misuse that information, but also because the cops are not technically competent to actually keep that information in a safe, secure, and private way, right? I think someone earlier was talking about different trainings for different states in the United States for different law enforcement agencies, and most of those law enforcement agents are not really taught about information technology and how you deal with it. Now, think about their literacy levels and then downgrade it to a much lower level when we're talking about information technology in an Indian context, because just the penetration of ICT services in India is a lot lower than the United States. And so they don't even have exposure to a lot of these services. But now what they do have, they have basically a get-out-of-jail-free card to do whatever they want to with that technology. So wiretapping is one of the key problems, which basically led to, there's a professor from Australia who says that India is therefore one of the few countries that have enacted data privacy laws for its private sector, but not for its public sector. Now, why should you care about it, right? I mean, I'm guessing most of you are not Indians, right? Well, you should care about it because of cloud computing services, because of business process outsourcing, because a lot of your servers and a lot of your information is right now being transmitted to jurisdictions that you don't necessarily have direct control over, right? If you are using cloud computing services, Amazon's cloud computing servers might be located in India, right? If you are using Gmail, their web hosting servers might be located in India. So those are all, that is all information that the Indian government can ask for without any reason, right? They don't need to have, if I remember correctly, they don't even need to have a suspicion. Now, what is critical to understand is a lot of these provisions were previously passed under something called Prevention of Terrorist Act, which is the brother of Patriot Act in the United States. So